The Law Palace TV, Law Within a Page.
We are going to look at trials. We are going to look at trials in an open court of law. Whether it is a criminal trials, we will look at it, and then thereafter we will look at a civil trial. By the provision of the Constitution, particularly Section 36, Sub 5 of the 1999 Constitution, an accused person is presumed innocent until the contrary is proved. Hence, when an accused person or a defendant or the Administration of Criminal Justice Act, ACJA, now refer accused person as defendant. So when an accused person or a defendant to a criminal trial is brought before the court of law, the first thing that will be conducted in the open court is arraignment. And the arraignment is made immediately the clerk called for the case, wherein the accused person or defendant to the trial, the criminal trial, will be ordered to step out and stand at the box. And right there, the charge will be read to him in the language which he understands, because that is a constitutional right. That an accused person upon arraignment before the court of law, the charge must be read to him in the language he understands. If he understands the language of the court, which is English or Latin, then he will be asked by the judge to take his plea. His lordship will particularly ask him, do you understand the charge? And he will answer yes. If the accused do not understand the English language, then an interpreter will be provided by the judge, by the court, which of course the accused person will not pay a dime to interpret the charge in the language of the accused. And having understood it, he will be ordered to take his plea. Now, in practice, where the accused plead guilty, and it's a capital offense, in other words, an offense which the punishment is death, or which the punishment is life imprisonment, where he pleaded guilty, the judge must record a plea of not guilty for him. But where it is a simple or misdemeanors offense, the judge will enter a summary judgment. In other words, the judge is going to convict him and sentence him, because the punishment is a lighter one. But if it is a capital offense, the judge will enter a plea of not guilty. Immediately the accused take his plea under the law, the accused has been properly arraigned. He has been arraigned before the court of law. For purpose of bar final, you need to understand that from the detention center of whatever law enforcement agency arrested the accused person to the courtroom, the accused is nobody but is a suspect. He goes by the name a suspect. His name changed from suspect to accused. Immediately he is arraigned and he pleaded not guilty. Now, when he pleaded guilty, his name changed from accused person to convict. So you see the three names now. Suspect, from suspect to accused, from accused to convict, where he pleaded guilty, or where the offense has been proved beyond reasonable doubt, and the judge convicts him, he becomes a convict, from accused to convict. But of course, when he was not convicted, he is discharged and acquitted, so he will never be addressed as a convict. But now, what is the procedure to be followed where in a capital offense an accused person plead guilty? The first procedure is that the judge will enter a plea of not guilty. The next procedure is that the judge must believe that the accused person is not sane, it's not sound, it's not normal. And then he will order the prosecutor to take the accused person to a specialized government hospital where the brain cell of the accused person will be checked to know whether it is moving clockwise or anti-clockwise. Of course, if the brain is moving anti-clockwise, it is an evidence of insanity. And then in the next adjourned date, the report of the soundness of the brain, body, mind, and soul of the accused person will be brought before the court. Now, if after the test is conducted and the report is positive that the accused person is sound, hale, and hearty, on the next adjourned date, the judge will still ask the accused to take a second plea, even after seeing the report that he is normal. If he still plead guilty, the judge will have to encourage him by saying, look, forget the fact that you have earlier pleaded guilty. It is your right to change your plea. If he still maintains that he is guilty, another adjournment will be taken. On the third adjourned date, the judge will still ask you, look, you know the punishment of your crime? Yes. If he does not know, they will inform him. And he will still ask him to take his plea. And in asking him, he will tell him, accused, it is still your right to change your two previous pleas of being guilty to a plea of not guilty. It is still your right. And there, if he plead guilty, the judge fourth task is to call the prosecutor. Prosecutor, I know he has pleaded guilty, but come and establish your case. Come and establish. Still show me that indeed he is guilty. Now, lawyers to be. If you are the one in the shoe of the prosecutor, let me tell you what is expected of you to do. Let us assume the crime is murder. You are to stand before the court from the bar and begin to address. My Lord, it is a case of murder presented by the state against the accused person. You mention his My Lord, before you we have three witnesses and one evidence. My Lord, my strongest evidence is the jackknife, which is the real evidence, the weapon that the accused person used to kill the deceased. Here is the knife. The fingerprint that was on this knife is the same with that of the fingerprint of the accused person. You show the knife to the court. My Lord, here is the knife. The investigation police officer is in possession. He presented it before the court. My Lord, beside this evidence, I have three witnesses who are even before the court. And they saw him. They are eyewitness to the murder. They were in the same house, unknown to the accused, when he was killing the deceased. This is how he will present. Say, my Lord, with this explanation, coupled with his plea of guilt, I advise you to go with the justice of the law and impose the highest punishment known to law. It is just the summary. My Lord, this is my humble submission. Take your seat. That is all that the judge required of you to do. And then the judge, the case will be adjourned for the last day, and that day is the day of judgment, wherein, of course, the accused will be sentenced to death. He will become a convict and sentenced to death. That is just an elementary aspect of trial. The main part of trial is this. Let us assume the accused person did not plead guilty. Charge has been read, he understood, and he has taken the plea of not guilty. Now, future lawyers to be, let us assume you are the state counsel to prosecute the accused person. And you have three witnesses in this case of murder. Let us assume it is the state against Abiola Mustafa. Now you have these three witnesses. How do you lead this witness? It's an integral aspect of trial. You are going to call three witnesses that will prove a case of murder against Abiola Mustafa beyond reasonable doubt. The police recover a knife. This knife was taken for fingerprint. The test is conducted, it is the same fingerprint. The first question is, who is going to give this evidence as prosecutor? It is the medical doctor that conducted the test on that fingerprint. And his evidence is an expert evidence. You have two other witnesses who were there when the accused was committing killing the deceased. They are going to give eyewitness testimony. And that is what we call direct evidence when we consider types of evidence. Now, how do you lead the doctor that is coming to give expert evidence? This is how you lead him. He has already been brought to witness box. He has been sworn. And how do we swear them in? Because these are Questions that will be asked in bar final exam. How is it sworn? Immediately he is brought to witness box. The clerk will ask, are you a Christian or a Muslim? Christian. Then the Bible will be given to him to hold at his right hand. He will raise it up and repeat after me. I, Dr. Secondus, or here, repeat his name, swear that the evidence I shall give shall be the truth, the only truth, and nothing but the truth. So help me God. Having sworn. It means every evidence he is giving is a sworn evidence. And sworn evidence is an evidence that the judge can convict upon by the provision of section 285 of the Evidence Act. It's different from unsworn evidence. So I haven't sworn. You now come to lead him. And he is going to give evidence on examination in chief. Because he is a witness to the prosecution. A witness coming to testify in chief is a witness that is going to give testimony in favor of the prosecutor or the plaintiff if it is in a civil matter. That's why it's called witness in chief. You are coming to support your chief. Your chief is your boss, the person that you share the same interest. Now, how do you lead him? You will lead him by asking him 3 introductory questions. The first 3 questions you are going to ask him is called 3 introductory questions. For purpose of bar final, you can ask these 3 introductory questions as in open question or closed question. Closed question we equally call leading question. Example now of an open question. Tell this honorable court your name. That's an open question. I already know his name as a state prosecutor. Put yourself in the shoe of the prosecutor. He is Dr. Secondus Ohia. But if you don't want an open question, you can give a closed or leading question, which will be, I believe your name is Dr. Secondus Ohia. Am I correct? He will say yes. That's a leading question. Because it's a question that suggests a yes or no answer. So, what are the 3 introductory questions? 1, tell this honorable court your name. My name is Dr. Secondus Ohia. Your occupation. Second question. I am a medical practitioner. Your address. I am the chief medical director of the Federal Medical Center. Because the address could be an office address or a residential address. Full stop. Because he is an expert, the law only allows him to give evidence after he has established the fact that indeed he is an expert. Otherwise, he will not be allowed to testify. And what is your next question? You say you are a medical doctor. You say yes. What do you have to show as proof that indeed you are a medical doctor? He said yes. By my degree certificate from the MBBS, my ID card, that's my identity card. Of course, by that time, all these evidence are already in your possession as a prosecution. Okay, if you look at this document and card, how do you identify to be your own? My name is written there. Then you pick the ID card and show him. You give it to the clerk give it to him. Is it the ID card you are referring to? He will say yes. Then it will be given back to the clerk will give it to you. And then the certificate will be given to clerk to him. You say, is this your certificate? He will say yes. The clerk will return it to you. And then you can now tell the court, my Lord, I seek to tender these two documents as proof that indeed the witness is an expert in medicine and science.
Thank you for watching the Lord Palace TV. For more interesting content,